Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. It's a pretty simple concept, I think. All right, we have a question from Darnell Jenkins, YouTube user Darnell Jenkins, who I believe asks some of the finest questions we have ever answered on this channel. And this is also great. So Darnell asked us, and I'll read the question into the record. Hey Vince, I hope you're well. I am. I'm back on the hobby farm, loving life. I have another question or concern. When an attorney agrees to take your case and to work off a contingency, what is included in that fee? I do understand that basically you get paid whatever your client is awarded. You get 33%, correct? Okay, so that's the percentage you set with your attorney, then that's what your attorney gets, 33%. Does that percentage include mediation, filing a right to sue letter with the courts? What is the 33%? I hope this question is one that you would consider answering publicly. Here we are. To help others who may be like me, the reason why I ask is because when I brought my claim to my attorney, I didn't know much about the whole legal process. Yeah, it's not your job to. Hopefully you only have one of these in your life. Two, maybe. But it's never ideal to experience discrimination in the workplace or sexual harassment, right? So, you shouldn't know that much about it. I always use the example of like a surgeon, right? If I'm going to hire a surgeon, I don't know a lot about hiring surgeons. I don't know a lot about hiring architects. I don't know what you do, but I probably don't know a lot about it, right? So, you're in a realm where it's not your thing, and it's kind of on us, the attorneys, to give you the information, in my opinion. It's kind of why the channel exists. But at the time of my consultation, the attorney felt I had some valid claims. Clearly, he took your case and decided to take my case. At that time, I was broke. Couldn't afford a lawyer, couldn't afford representing myself. So I was in a position where I was broke and I couldn't be picky. I had to take whoever accepted me. That is tough. He agreed to represent me on a full contingency. When I settled, I knew he would get 33%. But my attorney also deducted other fees, mediation fees, court filing fees, that I assumed would just go into the 33% that he was going to receive. So when I get my award, it was less than I expected. Not a great feeling. This is because I feel like I was blindsided and had no knowledge of what attorney's fees were and were not covered by that 30%. I'm hoping you can make it make sense. Thanks. You're a fan. Oh, thank you. I'm a fan of your questions and a fan of you. I'm glad. At least it sounds like you won. I don't know if you got as much as you wanted, but at least it sounds like you've carried the day here. You've been victorious. So to answer your question, you're essentially asking me about costs, right? So I have no idea what your attorney put into your case in terms of costs. I can tell you this. If I take a case, generally speaking, depending on the level, like if the case is in the agencies, like the EEOC, generally we're going to be spending somewhere between $10,000 and $20,000 by the time it's done. If we go to federal litigation, it can easily hit 40. I've seen it hit 80, 90, 100K. Stuff gets expensive. Filing fees, deposition costs, court reporters, expert witnesses is really where the money goes. Sometimes you need massive doc review jobs that I need to staff up. I need extra attorneys for, right? And where we're allowed to, our firm covers all of that and does not recoup it out of the client. We say, hey, that comes out of our percentage, the end. That's not always allowed, believe it or not. In some areas, that's frowned upon ethically by the Bar Association in certain jurisdictions. And those jurisdictions, you have to recoup costs. Now, that's just the first complicating factor. The next thing is that I just told you what our firm likes to do. That is not what every firm likes to do, right? So when somebody calls me up, a lot of times I'll say, hey, you shouldn't hire me. You should hire local counsel. It'll be way cheaper. When you look to hire local counsel, look at how they're handling expenses, right? Because that can be a lot of money. It can be money out of your settlement. It can be worse. If you lose, they can just send you an invoice for all that money. It's a nightmare, right? So you have to look in the retainer agreement for how the given attorney handles the fees. And it's not always so easy. People have sent me retainer agreements to look at, and I've read that retainer agreement. And my only takeaway from that retainer agreement is I have many questions about all the details of this deal. Why is so much unsaid? right? And that's disturbing. You don't want that from an attorney. So, quick note, people will often be excited about short retainer agreements. They'll be like, oh, cool, this guy keeps his retainer agreement simple to help me. Nah. No, that guy keeps his retainer agreement simple to leave things unsaid so they operate in terms of the defaults of his jurisdiction, which might be in his benefit because lawyers write the laws, right? So often the longer, more complex retainer agreement that spells out all of your rights, all of your responsibilities, all of your expectations can do a lot more to let you know what's coming and a whole lot more to protect you and your rights than the simple 1 or 2 pager. Like, I've seen some dudes, like really simple ones, like, hey, we're going to file this case and I'm going to take a percentage of whatever I win for you and I get costs, right? That you can do it in a paragraph if you really want to. That's not great. It's not ideal. Darnell, I have no idea what his retainer agreement said. I have no idea if he was being open and honest with you. I don't know if he even lived up to the agreement. I have no idea. But your question, one, makes me sad because I wanted you to have more money in your pocket. But two, I think it's really important, right? When people are hiring an attorney, even if they feel like there's a power disparity, like, oh, I got this, I need to take this attorney up on his deal because I'm worried I might not get an attorney. Okay, sure, that's not great. I don't love that. There should be more employment attorneys in the world. If there was more employment attorneys, all these employment attorneys wouldn't be quite so choosy, right? And that goes for myself. Like, we're fairly choosy. We're pretty tight with what cases we take, to be honest with you. We don't take cases that we don't believe we can win, right? That's great for us. It's great for our clients that we take on because they know we believe in the case. But there's a lot of people who, like, are big risks who we might have helped if we took their case. But we just look at the case and we say, hey, up front with you, this is a massive amount of risk for us. We can't afford to take this on for you, right? Doesn't make you friends. I'll tell you right now. Maybe some enemies that way. Got me a couple of death threats that way. Being honest isn't fun, right? But it's also important. You got to say, listen, you have a claim. I think this case could win. I can't afford to cover your expenses and put in hundreds of hours of attorney time into this case because it would be too high risk, right? It's going to cost me 10, 20, 30, 40, 60, whatever it is, $1,000. And I don't really know if we're going to win or not. So I can't really give you the deal you want. People don't like that. But that's really the only way you can have that conversation. People don't. A lot of people just say, hey, call me later. Call me later. We'll talk then. Call me after your EEOC. We'll talk then. I don't go in for that. But the only answer to your question is it's different depending on where you are and what the retainer agreement says. And it's not unheard of for the retainer agreement to say things that are not legal in a given jurisdiction. Attorneys do that and often get away with it. It's also not unheard of for attorneys to just have a retainer agreement that doesn't spell things out and then just tell you what the deal is later. And if that's something that went on, if your retainer agreement doesn't give voice to these costs being scooped out from your side, there might be something to look at a fee dispute with. There might be something to contact your local bar association about, right? There might be ways to address it if you've been wronged, is what I would say to you. I hope this is helpful. I hope you can look at that retainer agreement and see if he was up front and this was the deal, then it was the deal, and so be it. As long as the deal is legal where you are, then you're probably bound by the deal, right? And to your point, you took the deal because it was better than not having representation. Yeah, and I wish you had more options, but you made a choice. And you made a smart choice because you got some money. I just wish you got more money. That's what I'm saying. If this was helpful, like, subscribe, share, comment down below. Helps me to help more people just like you. Remember, everybody works. Not everybody wins. Be smart out there.